Guys, I have some earth-shattering breaking news today when it comes to the TCPA rules. You've probably heard that the rules got postponed. I have even bigger breaking news than that. Before I share that with you, I want to share with you this email that I got Friday, and it goes like this. The FCC just made cold calls illegal. So right then and there, this person told a lie because these new rules had nothing to do with cold calling or making cold calls illegal, nothing to do with what we do as agents. Let me make that perfectly clear because a lot of agents worried about this. And the reason they're worried about it is because of emails like this and people like this on social media trying to scare real estate agents into thinking that cold calls are going to be banned or that we can't text and we can't do this and we can't do that and that we're going to get these big fines and trying to scare agents literally into buying whatever their thing is. Okay. And just so you know, that's not what I do at all whatsoever. What I do is share everything with you freely so you can make the best decisions possible about your business. This entire TCPA thing, I've been right there the entire time telling you exactly what it is, step by step. And I see emails like this, and I've gotten a bunch of them, and I see stuff on social media. And I just want you to know that they're just trying to scare you into selling you their thing. If you dig into the email even further, it talks about in beginning in 3 days, right? January 27th. So they sent this Friday morning-ish. Let's see, what time was it? 11:35. A new update to the Telephone Consumer Protection Act will take effect, effectively banning cold calling without one-to-one consent. Totally false, right? In a move designed to safeguard consumer privacy and curb intrusive telemarketing practices, you can no longer call for sale by owner leads. The same way you always have. That's crazy to even say, to put that in writing and send it out, knowing that you're just trying to manipulate people and manipulate agents into whatever it is that you're selling, whatever it might be. There are big penalties if you break these rules. What rules? You know what I'm saying? And watch the video below to find out what the new law is and how to get around it. Yeah, I'm sure you have the answer right then and there. All they have to do is sign up for a good 3,000 bucks and all their problems will essentially go away. Guys, listen, I just wanted to, make this to let you know. Number one, there's some breaking news I want to share with you that's really earth-shattering when it comes to this subject here. But secondly, like, I share everything with you for free so that you can make the best decision possible. All right. In the light of what's happening with this and everybody freaking out, I'm going to do a Zoom call tomorrow and I'm just going to sit down and not try to sell you anything. I want to sit down and show you, teach you the methodologies behind actually talking to a prospect, right? Actually talking, not reading a script, not handling objections, not trying to use psychology to trick them in the first couple seconds to agree to have a conversation with you. That's not how I communicate. I don't communicate manipulatively. I don't communicate trying to trick people into talking to me. I talk to people and I'm real when I talk to people and I have a real conversation. And my objective is to connect with them, get them to tell me exactly what it is they want to do and why so that I can help them do it. I'm going to teach you how to do it on this Zoom call tomorrow. Let's see what time I'm going to do that. I'm going to do that at 2 p.m. Eastern. I'll put the Zoom link in the description below. But I just wanted to say that before I got into what's happening here. Okay, so I got a text message from a CEO Friday, pretty late. Right. And we all know by now, if you don't know that, I mean, it's been all over social and everything, that these new rules that were going to come into effect today got postponed for a year. Okay. As of Friday afternoon. And so, what now to all the people that were saying that cold calls are illegal and you can't cold call anymore and you need to come buy my thing? Are you going to rectify all that now? Or are you going to come back and say, no, you know what? Everything I said, even though it was a lie to begin with, it's really not true now. No, 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 no. I'm sure you're not going to do that. You're going to go a different direction and pretend like this didn't happen. But I got a text message from a CEO, and it was a link to this, a TCPA World, talking about that this thing got postponed up for effectively up to a year. And I was like, what does that mean? And after digging in, I realized it was like the entire thing, all the rules that they were talking about were effectively postponed. Okay. For these reasons, let's see. they didn't really say the reasons in this thing, but I'm fixing to get into the reasons. I'm going to tell you, give you more information here. We find that the justice requires postponement of the effective date of the rule, and we therefore postpone the effective date for up to a year, which is very interesting. So, just before I get into this article about the actual breaking news, I just want to say that these everybody was freaking out about this, but the thing is it had to do. There were four main things with the new rules: robocalls, which is not the same thing as auto dialers. What we do as auto dialers on RedX and Mojo and stuff had nothing to do with the new rules, right? It was business as usual. The DNC rules haven't changed at all, weren't going to change. Robocalls, text messaging, that were coming down a little harder on text messaging. You've got AI, if you're using AI to call, if you're doing voicemail blasts, if you're doing anything, that pre recorded thing, that was going to be looked at a lot harder, but also lead gen for these companies that sell leads. They can only sell leads to one agent versus multiple agents. So that just tells me that there was a lot of that going on. But again, when I dug into this, I realized this didn't have a lot to do with real estate agents, as you'll find out momentarily. I did a lot of research this weekend, and I found this article. So this article really broke it down. Okay, the 11th Circuit vacates. Okay, here's the breaking news: vacates, which means removed the TCPA one-on-one consent rule immediately after the FCC postpones its effective date. So not only did they postpone it, but then just shortly after that, they completely vacated it. Right, according to this. And so, we'll find more as time goes on here, because I'm sure there'll be appeals, there'll be a process, legal proceedings, and stuff like that. But on the eve of prior to its effective date, the eve, right, which is yesterday, the FCC one-to-one consent rule, which sought to redefine the meaning of prior express written consent under the TCPA, was postponed for 1 year by the FCC's Consumer and Government Affairs Bureau. Just minutes thereafter, the rule was struck down by the U.S. Court of Appeals in the 11th Circuit, right? So the background is that in 2012, the FCC established that these calls and text messages for marketing purpose must have written express prior consent, defined as an agreement in writing. Okay, so that's kind of the background that was created. And then in 2024, right, January 26, 2024, they came in. And because of the advancements in technology and like the uptick in text messaging and AI and all these different things, they had to kind of come in and say, okay, we got to establish some new rules here around some of this, because it's starting to get a little bit crazy. And so, they came in and it created these new rules. They put them in front of the courts January 26, 2026. Okay, I mean 2024. Okay, so a year ago, and then. And then since then, literally the day that they put those rules that they submitted to the courts about these new rules back in 2024, that day, okay, you had a company called the IMC, right, which is the insurance marketing coalition. Okay, this is the big player right here, the IMC, that was against the FCC when it comes to these new rules. We stand as a steadfast advocacy organization within the insurance industry, committed to safeguarding educated and informed consumer choice and access to essential life, health, and Medicare insurance products. And if you look right here, this is on their homepage of their website, become a member. And if you look down at the bottom, it says, as need arises, we form committees and task force to create impact. Recently, that's included bringing a case against the FCC and their one-to-one rule, and has included an annual letter to the CMS to address specific points in the yearly proposed rule changes for Medicare. So you see, this has a lot to do with these other industries. And if you notice, real estate isn't even in here. So, I could bore you with all this legal jargon, of how all this kind of like came to be and what all the legal proceedings were. I'm not going to do that. I'm just going to come down here and kind of show you the fact that in the adoption of the second text blocking report and order, several submissions have asked the commission to revise or postpone the rule and have made a clear showing of the rule's compliance burden. Okay, and so the companies were as follows. You get a letter from the attorney of Lending Tree, okay, which that's in the real estate family, but it's mortgage, it's not real estate agents. Okay, requesting a revision to the new rule permit curated comparison shopping. Okay, then you got the IMC, which we just covered. They stated that there would be adverse consequences from the commission's one-to-one and logically, topically associated consent requirements on small businesses. You got a letter from Reach, which Reach is in also in the real estate family when it comes to affordable housing, and they said they were requesting that the commission change the phrase "one identified seller" to "one identified seller, entity, or brand" to alleviate many of the unintended consequences stemming from the current language of the one-to-one rule. A letter from the attorney of Quinn Street, which is basically a consumer research company. They were requesting that the commission adopt Lending Tree's proposal for a narrow exception of the one-to-one consent rule for curated comparison shopping platforms. Okay, then you have another letter from Lending Tree saying that small businesses will suffer a loss when compared to nationwide name brand providers. So basically saying that small businesses, it'll put them at a disadvantage, these new rules. Okay. And then the IMC again said that its members will suffer irreparable harm from the order, including damage to their business operations, significant compliance costs, and the chilling of their speech. So you see, a lot of this didn't have anything to do with real estate aid. Like none of this was like brokerages or real estate agents, coming in and writing these letters, so on and so forth. So if you scroll down and start looking at the rest of this, what you'll find is that they postponed these rules, right, for a year, and then they came out and vacated these rules. Okay, and then what I found was very interesting is that these few paragraphs here, with respect to the one-to-one consent requirement, the court held our cases show that given prior express consent to receive a robocall, one need only clearly and unmistakably state before receiving the robocall that the consumer is willing to receive the robocall. One-to-one consent is not required. The court held that because the one-to-one consent restriction attempts to alter what we have said is the originary common law meaning of prior express consent, the restriction falls outside the scope of the FCC's statutory authority to implement the TCPA. So they were saying, wait a minute, FCC, you're overstepping your boundary here on your authority to implement the TCPA. This is huge. Additionally, the court held that the FCC's their own brief provides even more support that the court's conclusion for the court's conclusion because it concedes that the consumer could give prior express consent to numerous intermediaries under the TCPA, whereas 2023 order states otherwise. So they contradicted themselves. The court then turned their attention to the logical and topically related issue. In doing so, the court held that the FCC exceeded its authority under the TCPA. Whether a consumer can be presumed to consent to robocalls in a particular situation says nothing about whether the consumer has in fact consented to the robocalls in that situation, as long as the consumer clearly, unmistakably states before receiving the robocall that he is willing to receive the robocall. He has given prior express consent under the TCPA, right? It's anticipated that the SEC will address the 11th Circuit ruling shortly. So you see, again, this literally has nothing to do with real estate agents, how we do business. The rules had nothing to do with how we operate. Let's put it like this. If you were in compliance before, you are in compliance now. If you were out of compliance before, you're out of compliance now. There's nothing that, even if the rules came into effect, would have changed about the way that you do your business. Let me be perfectly clear. And anybody that says otherwise, I just want you to take a step back and say, okay, what is this person selling? What is their product? Right? And it's telling me that these rules are going to effectively change the way and ban the way that I've been doing business or that I want to do business or makes me take a step back from what I'm doing. Does that fear cause me to be more interested in whatever their products are? That is a good question. Is that a good question?